Kathy. Good morning. Like Bill, it's some personal significance to be here to address you. I've been in Croatia for maybe 3 or 4 times in the past decade, but this is probably the first time in 50 years, almost 50 years since that I've been to Dubrovnik. Since I'm not Croatian, I'm Macedonian, born in Skopje, so I can say dobro jutro to you all. Let's start with sorry, let me just get the slides going. There we go. Did I just turn it off? Okay. Kathy set the stage that we're talking about a problematic merger from the outset, and a merger that will likely impact multiple jurisdictions. So with that start, I think it's a fundamental issue that you have to deal with it or treat the process as a campaign. And so you begin with appointing lead counsel, somebody to coordinate the campaign. The role of lead counsel is probably less that of a general than a quartermaster, somebody who's responsible to, or a traffic policeman, somebody whose principal role is making sure that the resources are there, that people are telling a consistent story, that the story is in fact accurate, it's the right story to tell. The right in the truthful sense of the word, as opposed to just the advocacy part of it. But the advocacy, of course, is important. So there's a lot of steering of different paths. And then there are timing issues, coordination issues, remedy issues, a whole host of things that each of us will talk about in turn. So at the outset, of course, what you start with is a very detailed assessment of the competition, the competitive impacts of the proposed transaction. And for that, of course, you're going to need local counsel, and equally important, you're going to need economic expertise. Because at the end of the day, antitrust, as other speakers have pointed out, at the end of the day, the idiom, the intellectual idiom of competition law is microeconomics. And that's what you need to inform your legal analysis. The legal analysis will vary from jurisdiction to jurisdiction, but as I say, the theoretical basis of all of our analyses is ultimately going to be a microeconomic base. So you need to marshal the economic facts and evidence and the economic analysis that goes with it. It's good to be a lawyer, and as a lawyer, it's good to be familiar with and conversant in economics, but don't forget, you're not an economist. So we can always pretend lawyers have a habit of being amateur economists, and I dare say economists have a habit of being amateur lawyers. But remember, we have different professions and different attributes that we bring to them. So going from that, and I should also add, when you're talking about, as Kathy surmised at the beginning, multiple jurisdictions, there is another aspect to coordination, which is that if in mergers that are not notifiable among multiple jurisdictions, governments now routinely seek to you have to tell them who you're notifying to. In our form in Canada, it's a mandatory line that you have to indicate what other jurisdictions you're notifying. And the practice is increasingly for for agencies to ask for waivers of confidentiality in the filing so that they can talk to each other. I don't know if it's as common in the US. I think it is, by and large. The DOJ pretty much, and the EU probably as well. So those aren't mandatory, but if you're smart, you're going to figure out a way to come around to providing that waiver. Now, consistency in telling the story is important. In fact, it's fundamental, but you cannot be a slave to it. At the end of the day, a competition analysis across multiple jurisdictions may lead you to conclude and advocate for different markets in different jurisdictions. In fact, that's one of the fundamental questions that your economists are going to be dealing with. Are there different markets? Are there overlapping regional or global markets, or are they local markets even within individual jurisdictions? So those are all questions that you cannot prejudge, and similarly, telling a consistent analytical framework is important, but how that framework is applied from market to market and jurisdiction to jurisdiction may vary. So don't be a slave to consistency just for its own sake. The analysis has to be very fact and jurisdiction specific. Because at the end of the day, that is what each agency is concerned with. It's concerned with the economic impact in its territory, the territory that it covers. So, hopefully I got it right this time. No? Left and right. Now, planning the notification process, once you've done your preliminary analysis at a not a stratospheric, but say 20,000 foot level. Then you need to get into the process issues, which is identifying those jurisdictions where notification is mandatory. It'll depend on various size of parties, size of transaction thresholds would vary enormously from jurisdiction to jurisdiction. So, for example, take two examples, the EU, or three, EU, the US, and Canada. The EU has a massive size of parties jurisdiction, but member states have varying, smaller usually, size of parties. Canada and the US, even though the US is 10 times larger than us, their size of parties transaction is much lower than ours. Ours is very high, and our size of transaction thresholds are roughly similar. So they vary. They'll vary. And there's some jurisdictions, for example, I did a deal in, that involved assets in Kazakhstan last year. We had to notify there where I was astounded how low the size of transaction threshold was, but we had to do a mandatory filing. And it impacted on the transaction involving two public companies and the timing of the transaction. In fact, we had to restructure it to deal with some of the issues. So plan that out in terms of timing. Now, it may be that notification is not mandatory, but it's still advisable. And I'll give you one example from my jurisdiction. Just earlier this year, the commissioner filed an application to dissolve a transaction that had been closed involving a single landfill, that's a waste dump, in the mountains, in the Rocky Mountains of British Columbia. A single landfill, and that merger was worth a few $1 million. It's in single digits, and now it's facing an injunction or basically a dissolution application before courts. And Kathy mentioned to me yesterday, I think the DOJ recently brought an injunction application to stop or dissolve, I guess, a merger involving a single chicken hatching facility?
Yes.
Right.
That they saw was a merger to monopoly, and the value of the transaction was $3 million US, and this is currently being litigated in federal district court.
Right. Right. So that's a trend that's now increasing. My cynical side makes me wonder whether there's a little bit of make work here as the volume of global mergers has fallen, whether agencies are looking for something to do to justify keeping the cut at 10%, as Bill said, or maybe it should be more. But that's just my cynical side. We'll see whether, in fact, that pans out. But there's no question the trend across multiple jurisdictions is for agencies to focus not only on notifiable transactions, but to look at and, if necessary, challenge smaller transactions that are below the notification threshold. So all that deals with the issue of timing and coordinating that aspect of your process, of your merger process. Let me talk about something that can be controversial at times and very difficult to handle as a process and a legal matter, and that's the issue of coordinating between counsel. One of the typical things that we'll do in the course of a large multi-jurisdictional transaction is enter into a joint defense agreement that will bind the parties and their counsel to cooperating, to advising each other if they receive requests for information from the other agency, questionnaires and the like, not to advise each other if they're planning to meet, to circulate copies of submissions you make or propose to make for comment and the like. In other words, there should be a fairly high degree of cooperation between counsel for the various parties in the transaction. That said, and one of the things you hope to achieve by that agreement is to preserve the legal privilege, or secret professionnel in European terms, of those communications, the planning, the draft submissions, and the like. Big problem. Those of you who are in Europe and members of the European Union will be familiar with the Axel Nobel case, which limits the scope of privilege to EU counsel alone and excludes both in-house counsel and, I believe by inference at least, foreign counsel. So how you communicate as amongst counsel and as between counsel and the client is also important. Now, but don't forget, no amount of privilege is going to protect or shield the facts, the raw data that your client produces about its sales, its business activities. Those are not privileged under any circumstances. What you're trying to protect through these kinds of agreements and by cloaking certain acts under the veil of privilege is the planning, the strategizing, the thinking, the theorizing that counsel and the economists are doing in preparing the case. You don't want a draft document that has a misguided statement or a misguided analytical step suddenly being disclosed and the agency using, well, wait a minute, you said 2 months ago, your economist said 2 months ago that was a local market as opposed to a global market. How can you be changing your story now? Well, there may be many reasons why the story changes. You don't want to be having that argument because the clock is ticking, and if you're distracted on something that came out inadvertently because you did not cover it by privilege, you're going to lose precious time, precious energy, and precious momentum. So that's a very important process issue in a multi-jurisdiction merger context. And then